This is Tripp VanderWal, member of the Miller Johnson Employee Benefits and Executive Practice Group. Welcome to our July series, or our July webinar for the Employee Benefits Lunch Break series. We appreciate you having here. I have a guest with me who probably needs no further introduction. He's joined me on a couple of these before, but I have Jeff Gray with me. Jeff, you want to say hello?
Good afternoon, everyone.
So for those of you that have attended these webinars before, we have this every third Wednesday of the month at 12 p.m. Eastern time. So you can see the dates of our upcoming webinars. Our next one will be August 18. Please feel free on the evaluation form, which I believe a link will be provided. You can certainly suggest topics for upcoming webinar series, and if we get enough interest, we'll be happy to address those. Teeing off from our labor and employment colleagues, Rebecca Strauss and Sarah Willey, who on their podcast a couple weeks ago did employment issues that you should be aware of using temp agencies. We thought we would tee off on that and address some benefit issues, both in the health and welfare space and the retirement space. I will be addressing the health and welfare sector, and I'm going to let Jeff address the retirement issues. And I think this is a really pertinent topic here, because with labor shortages that we're seeing right now, I think more and more agencies are continuing to look to temporary staffing or leasing agencies to complement their workforce. And so this is an issue that's becoming particularly pertinent right now. And again, these are great solutions, but as always, there should, things that you should be aware of that we avoid any pitfalls. So I'm putting Jeff on the spot right now because Jeff actually came to Miller Johnson from in-house counsel. And I know that he looked at a lot of these issues when he was in-house counsel. So I am going to ask him, as I go through my presentation, if he has any, either insights or questions to ask me, I'm going to ask Jeff, please feel free to jump in. With that said, I'm going to get started again. I'm going to address the health and welfare issues. So, there's only a couple issues to address when we look at it from a health and welfare standpoint. But I think the most pertinent analysis, or the place to begin, is to decide who is the common law employer of the worker or the individual we're talking about. Is it the temporary staffing or leasing agency, or is it what we call the recipient employer? And that is a really, at least in the health and welfare space, a really pertinent question. And what the IRS relies on under the Internal Revenue Code, or the IRC, is what we call the common law agency test. And this test is actually really more addressed to trying to decide whether you are an employee or an independent contractor. So you will see as we go through some of the elements, it's kind of like trying to shove a square peg into a round hole, because some think, well, you'll see some of the factors say that really doesn't appear relevant here. And you're right, they're not relevant, but the IRS has continued to say, this is the test that we look to determine which entity, if one, is the common law employer. And again, that is the recipient organization, the person that the worker is, doing the work for, if you will, or is it the temporary staffing slash leasing agency. And of course, the IRS uses, like, again, what I said, the common law agency test, which of course is different from what the Department of Labor uses. They use what we call the economic reality test. And as you will see, the common law agency test has economic reality components to it, but that's not the end of the story. So for those of you on the line that are familiar with this issue is historically the IRS has really looked at a 20-factor test. And I think in the late 90s or early 2000s, they kind of finagled those 20 factor tests, and they dropped them into three different categories, and those would be the behavioral control elements, the financial control elements, and the relationship of the organization and the worker. So we'll walk through those one by one. So starting off with behavioral control, as you can see here, it considers which entity, again, the recipient organization or the temporary staffing firm or leasing agency, has the right to direct or control the worker, and how the task works they're doing is done, and how it's completed. And again, I think you'll see kind of one underlying element here is, again, the ability to direct and control the worker, whether or not the entity does it, is who has that right, is really going to be the driving force. So when you're looking at behavioral control, you're looking at which entity is giving the instructions or has the right to give instructions, again, as to how work is done, where it's done, when it's done, and how it's completed. And then another element is, again, training. Which entity is doing the training of the worker? So again, if it's the temporary staffing agency, back one slide, please, Jeff. I'll let you know when to go forward. Thanks, though. I appreciate it. Is if it's the temporary staffing agency that's giving the instructions, you're going to go here. Here's what you're going to do at this agency. You're going to report back to us, and here's the training that you're going to need. Then it's the temporary staffing or leasing agency that's probably, or at least it weighs in favor of them being the common law employer, versus if the recipient organization says, okay, I got you from XYZ leasing, here's what you're going to do for the day, or here's what you're going to do while you're here, that leaves in the recipient employer. And again, at risk of spoiling the end of the movie, the IRS generally assumes, except for very short-term assignments, that it is probably the recipient organization that is the common law employer. Next slide, please, Jeff. Thanks. Next one is financial control, and that considers which entity has the right to control the business aspects of the worker or the individual's job. And again, does the individual have business expenses that are not reimbursed? To the extent that they do, more likely to be, and again, this is where I think this is like shoving a square peg into a round hole, is more of an independent contractor. But again, who's I guess we could reframe this to who's reimbursing the individual's business expenses to the extent that they exist. Is it this leasing agency, or is it where they're working? The extent of the worker's investment, whether the worker is paid on a periodic or a flat fee or time and material basis, and then again, whether the individual can suffer can make a profit or loss in the working relationship. And again, this is more, I think, relevant to the independent contractor, but this is the test that we're dealt with. These are the cards that we have to play. Next slide, please, Jeff. And then relationship. And again, I think this goes to which entity has the right to direct and control the worker, which is in fact the most important. And you can actually see one of the factors in the relationship test is which entity provides the worker with employee benefits. And that seems to be like a roundabout or a circular question here, at least in our webinar, or the context of what we're speaking with, because we're trying to decide which entity is the common law employer, or which entity does the worker become a common law employee for purposes of employee benefits. So again, we have these three elements. They don't work out great. I would say if you're going to remember anything of this webinar about trying to decide which entity is the common law employer, it's the right to direct and control the workers is probably the most important. Next slide, please, Jeff. So how does this matter with health and welfare benefits? And I would say first it matters to eligibility. And the reason that's important is because most employer plans that I deal with, most employer health and welfare benefit plans, they exclude from eligibility anybody who's not on their payroll. which essentially means they exclude any temporary lease employees because they are on the payroll of the temporary staffing agency or the leasing agency. So if we offer them benefits and your eligibility excludes them, then we're running, we may be running afoul, if you're a fully insured plan, of the carrier's eligibility requirements, and you have an eligibility audit. They say, hey, it's nice that you provided Joe Smith, temporary staffing employee, with benefits, but they're not eligible under our health plan. So all those claims that they incurred, we're not obligated to cover them. Now, if you're self-funded, of course, you have a little bit more leeway. But if you're, have stop loss insurance, and this individual gets into the stop loss territory or has amounts counting to the aggregate, they're saying, no, eligibility audit, this person wasn't eligible. It's nice that you gave them health insurance, but that was on you. That was not on us. So I think it's important, to look at eligibility requirements when you're looking at these types of workers. Now, if your health plan does potentially cover these temporary or leased agency employees, again, I would say that's rare, but I think the common law employer test becomes very important, because if they are actually not your common law employer, you might have created a multiple employer welfare arrangement, or MIWA. And I don't really want to dive down all the rabbit holes that MIWAs bring to us, but let's just say it's one of those 4-letter words that we want to avoid. So again, I think eligibility is an important issue here, and one that we want to be sure that we at least address when we're using these types of workers. Next slide, please, Jeff. Waiting periods. I think this is another, and this would be, I think this comes up more in context of when you have a temporary or a leased employee and you're going to hire them directly at some point. Are we allowed to impose a waiting period? Because remember, the ACA, past 11 years ago now, generally says you can't have a waiting period in excess of 90 days. And so if I use Joe Smith through XYZ staffing agency for 90 days and they become eligible for XYZ staffing agency's health insurance after, first of the month after 60 days, and then I hire them, can I also impose a waiting period? And the answer is, under the waiting period rules, you probably can't. Because a waiting period is really defined as waiting period is defined as really just a period of time that must pass before someone who is otherwise eligible can join your health plan. And in this context, in the staffing agency, if your eligibility excludes temporary, people not on your payroll, then while they're working as a staffing agency employee, they're not eligible. They're not a waiting period. So if you hire them and you impose a waiting period, that is probably not going to be a violation of the 90-day waiting period. Now, keep in mind, and we're going to address this next, and this is actually going to be my last topic before I kick it over to Jeff, but probably one of the most important ones is for those folks out there that represent, a large employer, or the technical term is an applicable large employer, has more than 50 full-time employees, including those full-time equivalent employees, and you're subject to this ACA pay or play penalty or employer mandate, that may be problematic. And Jeff, why don't you advance the next slide and we'll address that right here. So again, the employer mandate really looks to who is the common law employer. They don't look to whether you're a temporary staffing agency. They don't look, whether there's a contract. They look, is it your common law employer? If you are, then you have the obligation to offer these folks health insurance to the extent they're full-time to avoid a pay or play penalty. And you'll see in my slide, the first bullet point is a quote that I pulled from the actual regulations from the IRS. And very simply, it isn't a parenthetical, but it says, in the typical case in which the PEO or professional employer organization or leasing firm or staffing firm is not the common law employer of the individual, which seems to suggest that the IRS says, hey, we think the typical case is the recipient organization is the common law employer, then you, recipient organization, you have the obligation to offer these folks health insurance. And when this guidance came out and proposed regulations back in 2013, as you can imagine, the staffing industry went nuts. Because if I am a recipient organization and I have the obligation to offer health insurance to avoid the pay or play penalty, I'm likely not going to use staffing agency. It really removes a lot of the benefits that these organizations can provide. And so the IRS, I think, heard a lot of complaints of that in the proposed regulations. So when they came out with the final regs, they kind of had what I'll call a safe harbor and said, hey, even if these, a work site, temporary staffing, leased employees are the common law employer of the recipient organization, if they are offered health coverage by the leasing agency or temporary staffing agency, we will treat that as an offer of coverage by the recipient organization if you charge a higher, if the leasing organization charges a quote unquote higher fee for any of those employees who enroll in health coverage versus those employees who waive health coverage. So, I remember going through a lot, and I think Jeff on the internal side remembers doing this a lot. Correct me if I'm wrong, Jeff, but going through a lot of these, these contract arrangements, leasing agency, and saying, we really need to pay you a little bit more for these types of employees if they enroll in your health insurance. And you'd be surprised because a lot of them are like, that's kind of not built into our work, our model. So I don't know if we can do that, but we really had to push back. I mean, Jeff, I'm gonna again, I'm unfairly put you on the spot, but if you have any, I think you remember going through this, correct?
Yeah, I do. At the time, this rule was controversial. I think the staffing agency firms thought, well, we can just charge an extra 2% or something and call it good, but that's not how it worked. So just the process of working with the agencies and getting them to understand how this rule works and getting them to apply a higher fee for just those employees who are enrolled in coverage was a real challenge. I think they ultimately came around, and it may be a little bit, at least it's on everybody's radar more now than it used to be, but it was definitely a challenge. And I think just broadly, part of the reason why we're having this conversation today is so that we can highlight these things to raise them with these agencies and with your other benefits providers, because I know in my experience, it was hit or miss. The agencies weren't really out there looking out for the client's best interest in some cases, because they're doing their own thing and they've got their own kind of vested interest in how this all plays out. And then the benefit providers too, sometimes you just get an off the cuff, maybe request for information about leased employees at the end of the year when testing is happening on the 401k plan. But at the time, at least I felt like we weren't getting a lot of proactive highlighting of potential issues with these temporary agency workers. So yeah, that's a long-winded answer to your question. The short answer, which is yes.
No, that is incredibly helpful. And it's one of those weird situations where you're going to the agency and saying, no, I want to pay you more. Please charge me more, right? And they're just like, that's
right.
Not our business model. We don't know. We're going to have to figure out how to do that. And I think a lot of them have come around to being able to do that now. But this was kind of thrust on them. And trust me, it would have been easier if they could have just charged you flat out, additional 2% to the entire workforce that they were placing with you. But no, you can charge that, but we need there to be an additional charge for those people that enrolled. And again, I think most people have come around, but that was a new one. And I remember having lots of discussions with agencies, temporary staffing agencies on behalf of clients, back in 14 and 15 and 16. So next slide, please.
Yeah. Actually, Tripp, we have a question that maybe I can put you on the spot about from somebody who's listening. And she said that there's an extra fee that's being charged by the temp agency, which I assume relates to health insurance and who takes it. But her question is, what happens if the client doesn't actually pay the extra fee that they're invoiced for? Is it based on whether you're getting charged, or do you have to actually pay it for it to work, I guess?
That is a very interesting question. I would say, obviously, the regulations don't get it go into that much detail, but I think, putting myself in, being the devil's advocate, if you will, and putting myself in the IRS's shoes, I can say that, my argument is this is just the facade, right? Okay, you have this line item here that says you're being charged an extra fee, but you're not actually paying it. And therefore, you're not meeting, the regulations requirement of paying a higher fee for those who are enrolled in coverage. And again, at least you have the documentation that says you are. But if the IRS is kind of this position that covers all of tax law that we call substance over form, right? You generally can't change the form of an arrangement to make it permissible if the substance of the arrangement is otherwise impermissible. And I think just kind of falsely charging a higher fee is problematic. So with that said, one more slide for me, and this goes relating, I'd love to talk about Form 1095-C reporting. I like to do it when I can do it in person, because I can hear this collective groan from everybody in the audience, because anybody that knows this requirement is frustrated by it every year. Hopefully it's getting easier. But again, remember, if you are the common law employer, you have the obligation to do the Form 1095-C reporting on behalf of those, common law employees that are your full-time employees, even if they're temporary staff or leasing employees. And that's true even if you're taking advantage of this quote unquote safe harbor where they're enrolling in coverage through the staffing agency. Now, that's the technical rule. But I would say what I have seen in reality is it's generally the staffing or leasing agency that is taking on that obligation. And where I tend to see in contracts is, I recognize the reality and say, okay, I'll try to modify contracts. Say, okay, you do this leasing agency, you do the 1095 reporting, but should it be audited by the IRS and it becomes our obligation, you will provide us with the necessary information so that we can do that reporting. Because again, the way the statute and the regs are written, it is the recipient organization's obligation to do that. Again, even if they're using this quote unquote safe harbor. Fortunately, we have gone through a lot of, I would say, unfortunately, we've gone through a lot of reporting penalty type issues where there's been reporting errors, and we've seen a lot of pay or play type proposed penalties assessed. And we're able, the fortunate part is we're able to get our clients out of those, because it tends to be just reporting mistakes. And they are taking, we haven't had to provide much in the way of documentation or evidence other than just a certification statement based on someone within the organization saying, I test that this is true. And the IRS has generally been okay with that. And the other fortunate part of it has not been an area of high audit activity, but that could always change. And remember, the Biden administration is trying to, to significantly increase the IRS's budget to increase the amount of people that are looking at, to quote unquote close the tax gap. So we could see in the future more audit activity and more invasive, I guess, what I would say, audit activity in this area. So keep that in mind. So again, the reality of the situation is the temporary staffing agency is likely going to do this, and they're going to want to do it on behalf of those employees. But I would try to look at the agreement and say, hey, if we end up as a recipient organization having to do this reporting on our employees, you're going to be obligated to give us the information. Maybe it's so much that you're basically filling out the 1095 or with everything but the payer or the taxpayer information, the entity's information. We're going to complete that. We're going to file along with us. So again, one other thing to keep your eye out for as you continue to use these types of workers. With that, Jeff, I will kick it over to you, and maybe I can have some insightful questions to ask you as we go through your portion
That sounds good. Yeah, thanks, Tripp. Let me back up a little bit. If you're confused right now about common law employment status and staffing agencies and professional employer organizations or PEOs, it's understandable, and it's in part, in my view, because the IRS is very inconsistent about that standard. You know, as you'll find in a second, Tripp talked about how there's this line in the pay or play penalties that talk about that imply or suggest that in the typical case, a staffing agency worker is the common law employee of the client or the service recipient. But then, as you'll see in the retirement plan space, the code really implies the opposite, that you can have someone who is taking primary direction and control from the client who is not the client or service recipient's common law employee. So we'll get into that a little bit, but the point, and another point in terms of background is just to keep in mind that those factors that Tripp identified, it's a multi-factor test and no one factor is determinative. So I think in many situations where you're dealing with a staffing agency and both sides are really taking the position that, hey, these workers are the common law employee of the staffing agency, not the staffing agency's client. In that case, we, I think, rightly emphasize that relationship factor, that these employees are usually hired by the staffing agency. They may get some basic training. They may get an employee handbook, employee benefits. If their assignment at the client ends, the staffing agency will reassign them somewhere else. That's all pretty significant control over the employment relationship, and I think supports common law employment status on behalf of the agency, which I think is what both parties expect most of the time. So with that little bit of background, let's talk about retirement plans. I think I found the clients are surprised about some of the rules related to temporary agency workers that are just baked right into the Internal Revenue Code as it relates to retirement plans. So if you had listened to the employment presentation on this previously, they probably talked a lot about misclassification of common law employment status. But here, it's kind of like the IRS takes the position that, okay, we're not going to talk about misclassification. We're just going to treat these people who meet these requirements as your common law employee, whether they are or not. So in that case, you could have agency workers who could potentially be entitled to service credit for eligibility investing that you were not anticipating. You could also run into issues with making distributions from a retirement plan available to someone who was, say, previously your employee, that then you moved over to the payroll of the staffing company. That can create an issue. And then lastly, you've got potential issues with minimum coverage testing, because as you'll see in the retirement plan space, we treat leased employees, which I'll define here in a second, as the common law, as a common law employee of the employer when it comes to certain requirements, including minimum coverage testing. So keep these in mind as we go through. This is the main definition of so-called leased employees. This is under Section 414N of the Internal Revenue Code. So under that code provision, a leased employee is any worker who is not the service recipient's common law employee. So not the agency's client's common law employee. That's the basic, because if they're a common law employee, then they're just treated like an employee anyway. So number one, not your common law employee. Number two, that they provide services to you as the service recipient pursuant to an agreement between you and this agreement with a third-party leasing organization, so a temp agency. There's some agreement in place where the worker provides services to you as the employer, as you as the service recipient pursuant to this agreement. To qualify as a leased employee, this person has to provide services to the service recipient on a substantially full-time basis for at least 1 year. So that's where I think a number of our clients kind of avoid this issue, is that when they have temp agency workers, they just have people maybe for 90 days or 60 days or something, and then they're off, the assignment ends, and these workers go work for someone else. That isn't always a solution, as I'll talk about in a second, when you actually hire these people onto your payroll. But especially for clients who have kind of long-term staffing agency workers, this is definitely an issue. And so finally, The final criteria for whether or not somebody is a leased employee is that the person works under the primary direction and control of the recipient. And that's where really the tension in all these rules is, because as I said at the very beginning, you're only a leased employee if you're not the common law employee. Yet in order to qualify as a leased employee, you're taking primary direction and control from the recipient, the agency's client. And I think that's just a tension in the rules. And if you meet the standard, you're basically deemed to be the common law employee of the client organization for certain retirement plan purposes, mostly compliance-related purposes, and like vesting, service credit, and testing. But there is one exception. If the leasing organization provides a money purchase pension plan with a high contribution of 10%, immediate vesting, and the leased employees are a relatively small percentage of the recipient's non-highly compensated workforce, then they are not counted as the service recipient's common law employees. I know that's confusing, and I kind of rushed through it because it's very rare. I've never even run into a staffing agency that had a money purchase pension plan with that high of a contribution. So for most people, this is just a non-exception. Doesn't really help. So what happens if you have a temp worker who meets that criteria? You've got a group of people there. They've been there for on a substantially full-time basis for at least a year, and they qualify as a leased employee. Well, at that point, they are eligible to participate in your 401k plan, meaning the client's 401k plan, unless there's an exclusion for these folks. And so oftentimes when you're looking at your 401k plan, if you use a kind of off-the-shelf plan, there's often a checkbox that says, yes, we exclude leased employees. And that's fine. That's better than not having the checkbox there if you're intending to exclude them. But it's also not necessarily the best way to do it. Because what happens if they are misclassified? What if you have this large group of leased employees? You've got an exclusion for leased employees as defined in the code, but then it turns out that the IRS or someone else says, well, wait a minute, they were misclassified. They were your common law employees all along, and therefore fit within your eligibility criteria in your plan. That's a problem, and that's something that you want to avoid. And in our plan document, we address this by basically defining that exclusion a little differently. We exclude workers who are on the payroll of a leasing organization, including any leased employees. And that way, if they're misclassified, if someone determines that they're misclassified, they're still excluded under that provision of the plan. So we don't have to make retroactive contributions or something for these folks. But there's a trade-off. So one of the outcomes of these rules is that leased employees have to be treated as common law employees for purposes of minimum coverage testing. So if you have a very large population of non-highly compensated employees who are excluded from participating in your plan, that can affect your minimum coverage testing. Of course, that's the test that determines, basically looks at eligibility. So you're comparing the ratio of highly compensated employees who are eligible to participate to the ratio of non-highly compensated employees who are eligible to participate. The general rule is the non-highs, that group has to be at least 70% of what the highly compensated ratio is. And so you can see why if suddenly you have this large group of leased employees who are excluded, that can throw off your testing and create a minimum coverage failure, which is a significant issue if it happens. As a practical matter, most 401k providers will ask you about this at the end of the year when they're doing the minimum coverage testing. Clients should pay attention to that and look into it and give a thoughtful answer rather than just saying, no, we don't have any leased employees. If in fact you have large groups of, or really any group of temporary workers there working for you. It can also impact service credit. So this is the so-called lease to hire rule. If you have a leased employee who you then hire, that individual is entitled to prior service credit for their work as a leased employee. And I think that's an area where this often gets goofed up because whoever's doing the hiring on the client side, on the service recipient side, they're oftentimes viewing this person as a brand new hire. They're coming off the payroll of the leasing agency or the temp agency and coming onto the employer payroll. So therefore, we'll apply the normal 90-day, 6-month waiting period, whatever it might be. And the answer to that is no. If the person actually qualified for that, qualified as a leased employee, you have to give them that prior service credit. So they may not be subject to a waiting period in terms of getting into your plan. And it's unclear, too, what happens if you say someone would have met the definition of leased employee and they've been there for a year. What if you hire them 6 months into their assignment? You have to give them 6 months credit. That's unclear under the rules. I think the conservative answer is yes, you would in that case. One more issue on service credit is vesting as well. A leased employee, once they're hired, is also entitled to vesting credit for their time spent as a leased employee. When it comes to vesting, the rule is very clear. You don't apply that kind of 1-year requirement for meeting leased employee status. So when I go back to that definition of leased employee, substantially full-time basis for at least 1 year, that's a general requirement. We are not allowed to kind of exclude that 1 year when it comes to giving somebody vesting credit towards the 401k plan after they're hired by the client organization. Again, that's a nuance that we've run into, right? You've got a client who hires temp agency workers on a fairly regular basis. They may have a 6-year vesting schedule under their plan. Maybe someone provided 2 years of service before being hired onto the client's payroll, then they leave after 2 years. Chances are their vesting credit is not going to be accurate. And that's a problem and something that HR and benefits people need to watch out for. Distributions too, and this is just a quick note, transfer to leased employment is not a distributable event under a 401k plan. So that normally, you leave employment, you can take a distribution from the 401k plan. If you actually take the distribution, it's not a rollover, and you're not age 59 and a half, there may be, there's an excise tax that applies. But what happens sometimes is, this example here, you've got a position that gets eliminated, and then somebody says, oh, wait a minute, this person turns out to be more important than we thought, and they need to stay on this project management team until this project is done, and so we'll just put them through the staffing agency. Well, that transfer to leased employment does not create a distributable event, and so you may need to kind of monitor the payroll system to prevent that person from taking a distribution until their assignment ends. The way this usually ends up not being a problem is if the person's older and the plan allows for in-service distributions. This person could have taken a distribution after 59 and a half anyway as an employee, and so usually that individual can take a distribution. But if they're younger or if there's no in-service distribution for that in the client's plan, you could have a problem if you allow someone to take a distribution when they move over to a staffing agency.
Hey,
this
Jeff,
is my last slide.
Before we move on to non-qualified, we got one question. I'm just gonna read it to you and see what your thoughts are. Is if you have many temps on assignment, but only a couple have been on assignment for more than 1 year, or for several seasons with a break in assignment each year, if those with 1 year don't account for 20% of all your non-highs, that would exclude the common law investing issue, correct?
And so the answer there is no. That 20% rule really only applies if all of those other factors are there as well. So it would apply. It would work. The answer to that would be yes if the staffing agency provided a money purchase pension plan with a 10% contribution, full immediate vesting, and that 20% rule applied. I think the way I kind of understood the question, unless you have those other components to the benefit plan that's offered by the agency, the 20% rule doesn't really help. So I guess the answer to that is no. You could still have, for those couple agency workers that are there for that long, if they meet the criteria for leased employee, you'd need to include them in your minimum coverage testing and make sure they're excluded from your plan if that's your intention. Chances are, if it's just a couple people, that probably won't affect the minimum coverage testing depending on the size of the employer. So it may be something that's fine, but you just want to work through that and take a look at it and make sure.
One other question that I have for you, Jeff, if that's okay, is if I am using a PEO, and so I have employees that are participating in my PEO's 401k plan, but they are truly common law employees of me or the recipient organization. Do I need to sign on as a co-sponsor of that PEO's 401k plan, or if I don't, is that problematic?
No, I think that's typically the way we handle those situations, because you have if the PEO is different than a staffing agency firm, which is what we're focusing on now. The PEO is more like almost like doing the payroll and benefits on the employer's behalf. And so, I think what often happens is if you do have two big groups of employees, and you've got the client has a plan and the PEO has a plan, in certain circumstances, if the client sponsors that PEO plan, then you avoid the minimum coverage problem. But I think a lot of times it's kind of all or nothing. The employer may have just all of its staff through the PEO, and then the employer ends up being a co-sponsor for that PEO's plan.
Gotcha. I appreciate that. That was my own curiosity. And I realized I took you a little bit outside of where you're talking about, but I appreciate that.
No problem. And then the last point here, just for those who are still with us, we went a little long today. The point to remember with non-qualified deferred compensation plans is that they often trigger payouts based on separation from service, because that's a permissible payment event under Section 409A of the code. And so there's this question when you move somebody from employment status to a temp agency, especially this happens with executives, surprisingly enough. And it's usually, it's hard to describe it. It's oftentimes like this person's leaving, they want to leave, but we want to do something for them where they stick around for like another year, maybe wrap things up. And so we'll just put them through this payroll to the staffing agency. The staffing agency didn't identify or hire them or anything else. So chances are they're probably going to be still be the common law employee of the service recipient or client. But then more specifically, unless that person's service level drops, whether it's through a staffing agency or as an independent contractor or what, kind of regardless of common law status, unless that service level drops below a certain amount, you will not have a separation from service, and you will not have a permanent permissible payment event under Section 409A. So that's something to keep an eye out for too. The default rule is that if both parties basically anticipate that this person won't provide any more than 20% of what their average service level was over the past 36 months, then, okay, the IRS and we all agree that they have had a separation from service and can take a distribution from a non-qualified plan if their service level drops that much. You can adjust that up to 50% in the plan, but it's got to be a provision in the plan that exists when the deferred comp is basically agreed to by the party. So apart from this classification or anything else, that's purely based on service level after the kind of quote unquote retirement or when they leave the client employer's payroll. So that's really, I think that's it on the retirement plan side. Hopefully, I know that was a lot of information and it's pretty convoluted stuff, but hopefully it's enough where if you have temp agency workers that you're at least thinking about these things and asking your providers about this when the right time comes.
Yes, Jeff, I think that's important. Is obviously this is complicated stuff. I think much more on your side than my side, but the goal of this webinar was to give you the issue spotting to issue spot some of these issues if you're going to use these types of relationships, because it's never fun to figure out after the fact when it's too late. So a pound of prevention or prevention is worth the cure, if you will.
Yeah.
An ounce of prevention is worth a pound of cure is what I was looking for there.
There you go.
Mm-hmm. We'll hang out here. I'm looking to see if we have any questions. I'm not seeing any come up. So again, thanks for everyone for joining us. We will make this webinar available on the firm's YouTube page, so you can re-watch it to the extent that you want. Otherwise, we will be back here. I believe it's August 18th with the topic to be determined. Thanks again for joining us, and everybody have a great rest of the week.